All right, welcome back, everybody. So we're going to introduce our next speaker. This is Kim Clark. It is my honor to introduce Kim Clark. She serves as the Senior Staff Attorney for Reproductive Rights, Health, and Justice at Legal Voice, a legal advocacy organization that seeks to advance the rights of women and the LGBTQ community throughout the Pacific Northwest, especially those who experience multiple intersecting systems of oppression and discrimination. She manages the Legal Voice portfolio of high-impact litigation matters, policy initiatives, and legal rights and education projects relating to reproductive rights, health and justice, and more. Kim has a broad level of experience from both the private sector and across the board, so I highly recommend you check out her portfolio. But without spending too much extra time, I want to get Kim Clark on here so we can hear about what she's been doing and what Legal Voice has been doing to help out people like myself all across the state and this nation.
Can folks see me? Because I'm not seeing myself on the screen.
Yes, we can see you now.
Okay, great. Okay. Good morning, everyone. My name is Kim Clark, and my pronouns are she and her. And I am a senior attorney at Legal Voice. And you've heard a little bit about Legal Voice, but the one thing I wanted to add to the description of what we do at Legal Voice is that we are really trying to center race equity in our work these days, which is something that I'm really proud of, and I think is something that is incredibly important to the movement to advance reproductive rights and reproductive justice. I was, and on behalf of Legal Voice also, I really want to thank you all for your support. We appreciate it tremendously. I was asked to speak about religious refusals at Catholic hospitals. But given everything that is going on in the world today, and I will get to religious refusals at Catholic hospitals because that's definitely part of my presentation. But given everything that's going on in the world today with this global pandemic that is disproportionately affecting communities of color and protests in the streets in all major cities, protesting systemic racism, and two major Supreme Court decisions that are likely to not be great looming just ahead, I really wanted to take a little liberty and broaden this discussion to really sort of draw, really connect the dots between abortion restrictions, racism, and what I see as sort of the weaponization of religion to advance an extremist anti-choice, anti-LGBTQ, and white supremacist agenda, both in Washington and across the country. And because I really think that it's our failure as a reproductive rights movement to shine a light on that history and to really expose the connection between the anti-choice movement and its history of white supremacy that really explains why we are where we are today. And I'll talk a little bit more about that in terms of the movement to advance reproductive freedom. And I have to say, sadly, I think the reproductive rights movement is still a little bit behind on that front. That said, I really want to acknowledge the work of some really brilliant women of color in the reproductive justice movement who have really done groundbreaking work, who've known this for decades and been writing about this for decades and have done groundbreaking work that I think is really critical to moving beyond where we are now, including Kimberly Crenshaw, Dorothy Roberts, Bell Hooks, Loretta Ross, Angela Davis, and so many more. And I know I'm going to be packing a lot into this brief presentation, but I eat, sleep, and breathe this stuff on a daily basis. And if there was anything that I could tell, or I could say to people like me, this is what I would want to talk about. And I don't pretend to be an expert in reproductive justice, but I really, I am definitely a committed student. And I think that this is a really important thing for folks to understand if we're going to move beyond where we are today. So next slide. Okay. Okay, so what do I mean when I say that all of these things, abortion restrictions, racism, and the weaponization of religion, are all connected? What I mean is that I want to echo what Alicia said about looking back at the history of reproductive oppression in our country, which includes both sexual assault and the history of restrictions on abortion and contraception. And if you look at that history, what you see is that the anti-choice movement is really deeply rooted in sexism, yes, but also deeply rooted in white supremacy. The criminalization of abortion and restrictions on access to contraception in the late 19th century really arose out of a white Anglo-Saxon Protestant fear of being overtaken demographically. And I think that history has really been lost, at least in our court cases to advance reproductive rights in the United States. And we have to acknowledge too that that racism itself has enabled reproductive oppression to perpetuate itself, insofar as white women and white feminism has failed to acknowledge the this racial history and even embraced the patriarchal structures that were imposed upon them, instead of coming together to fight it. Meanwhile, and the connection to religion is that meanwhile, we've allowed the anti-choice movement to really cloak itself in religion and use religion to kind of polish its public image, and without much opposition, use religion then to expand its base. And the result is that abortion rights today are more at risk than ever, 50 years after Roe v. Wade. And religion has really become weaponized, and not just as a cloak, but as a dagger. And we can talk about how religion is being weaponized in the second half of the presentation. Next slide. So I think this is just a critical moment in the movement to advance reproductive rights. Again, the failure of feminism to make the connection between reproductive oppression and systemic racism is literally killing women, and especially Black women. This moment, and the reason I really wanted to shift my presentation this morning, is that I think this moment should really be a wake-up call, that in the context of a global pandemic that's disproportionately impacting women of color and protests in the streets over systemic racism, we really can no longer afford to let the other side get away with claiming that this is an innocent debate about religion. And I think the third alarm bell that's not listed on this slide is the June medical decision, which we're expecting from the Supreme Court any moment. And then there's another decision as well called Little Sisters of the Poor versus Pennsylvania, which I'll talk about later in the presentation. Next slide. So June Medical versus Russo concerns a Louisiana statute that requires that all physicians at abortion facilities have admitting privileges within 30 miles of a clinic. And this is the exact same statute, literally the identical statute that the Supreme Court struck down only 4 years ago in Whole Women's Health versus Hellerstedt, identical to a similar Texas statute. And the only thing that has changed is the composition of the court, which is now more religious than it was 4 years ago, and more conservative. There are two issues, there are really two legal issues at issue in the June Medical case, really regardless of which one the court decides, which one the court uses to decide the case. June Medical has really will have tremendous implications for access to abortion across the country. The general consensus in the community of reproductive rights advocates is that the Supreme Court, given the procedural posture of the case, would not have taken the case if the outcome was going to be positive. In other words, if the court were simply going to uphold Whole Women's Health versus Hellerstedt, which it ruled in 4 years ago, the court wouldn't have granted cert to hear oral argument in the case. Next slide. So what's at stake? An adverse outcome in June Medical would mean that it would be extremely hard to challenge abortion restrictions, which would potentially basically gut Roe v. Wade and Casey versus Planned Parenthood. It would devastate abortion access across, in Louisiana in particular, but also it would have impacts across the country, because it would enable states to begin enacting more restrictive abortion, or more restrictive abortion statutes. And of course, it would perpetuate systemic racism, because the impact of all of these abortion restrictions is felt especially severely by Black and brown communities who already face greater barriers to access to healthcare in general and systemic racism in healthcare. And I think most importantly is that the significance of June Medical is not likely to be really understood until it's too late, because what it is likely to turn on is this issue of whether or not abortion providers have standing to assert the interests of their patients in abortion cases. And if they don't, it means that reproductive rights advocates will have to find individual plaintiffs to pregnant people to serve as plaintiffs in these cases. And of course, there's tremendous stigma attached to that. People don't want to be the poster child for these types of cases, assuming they're even aware of what the legal cause is of their lack of access to abortion care. And of course, a lawsuit like this long outlasts the duration of somebody's pregnancy. So it really will have a devastating, without looking like it's too serious, it will have a devastating impact on our ability to combat these types of restrictions. Next slide. So what will that mean for Washington? Obviously, Washington has very progressive laws on access to abortion and contraception, but that is entirely dependent on the legislature not changing the laws and voters not changing the laws either through initiative or referendum. And lest folks should feel like we have nothing to worry about, there is a heartbeat bill, Initiative 1698, that may in fact be on the ballot this November. So the anti-choice movement is hard at work even in Washington. Also, access in Washington will likely be burdened as Washington absorbs states or patients from other states. There's also the strong likelihood that extremist white supremacist groups who are already on the rise in Washington state will be emboldened. I'll talk about an example of that towards the end of the presentation as well. And then the point that I really want to make here, though, is that states like Washington, the rest of the country, reproductive rights and justice advocates across the country, state legislatures across the country, or friends in state legislatures across the country are really looking for Washington to lead. Abortion remaining legal really should be the floor and not the ceiling. We need to really be thinking about building a broader movement that respects the human rights of every person to be empowered and have the resources to care for their body, affirm their identity, and provide for themselves and their families with dignity and equality. And if we really care about liberty, equality, and human rights and combating systemic racism, then we really need to be far from cutting access to care. We should be expanding access to reproductive health care and gender-affirming care, ensuring access to birth control and over-the-counter contraception for all Washingtonians, addressing the maternal mortality crisis that our country faces, and ensuring that all students have access to sexual health education. But beyond that, ensuring that every person has the power and the resources to care for their bodies and provide for themselves and their families with dignity and equality, which is what reproductive justice is all about, also means putting a stop to the over-policing of Black and brown bodies. It means addressing systemic inequalities in our criminal justice system. It means addressing economic inequality, it means addressing environmental justice, and it means addressing education equity. And that is what the broader movement for reproductive justice is all about, and what I think we in Washington should really be thinking about. Next slide. Okay, so I was asked to talk about religious refusals, but just to reiterate, the problem of religious refusals really is part of a larger campaign in which today religion has really become weaponized in order to undermine the rights of women, the LGBTQ community, and to push a really extremist alt-right agenda. So religious refusals actually happen not just at hospitals, but throughout the healthcare system. So in health insurance, by pharmacies, and also by providers. But given the time constraints today, I'm going to stick to just talking about hospitals and health insurance policies. Next slide. So this is just a slide explaining the types of religious refusals you see. Religious refusals relating to contraception, abortion, fertility treatment, end-of-life care, and gender-affirming care. Next slide. You may be surprised to know again that as progressive as Washington is, it's one of only five states where more than 40% of the acute care hospitals are Catholic, or hospital beds are Catholic, and there are whole regions of the state that have no other facilities. And really, there's no way for patients to know that when they're in an emergency situation, that they're at a healthcare facility that may, for religious reasons and reasons having absolutely nothing to do with what is in their best interest from a medical standpoint, they may not be able to access care. And I just included a list of healthcare services that the U.S. Conference of Catholic Bishops explicitly bans, and that's the entity that dictates what Catholic hospitals, what types of services Catholic hospitals can and cannot provide. Next slide. So Legal Voice and the ACLU and advocates from across Washington came together to try to address the issue of religious refusals with the Protecting Patient Care Act, which was really a three-part effort which began in 2019, in which the legislature passed a statute that requires hospitals to post a checklist of services that they don't provide. And then I've listed the types of services that are included in that checklist. And that's a great step in the right direction, but of course the problem is if you're in an emergency situation, you might not have the time or the knowledge to check the hospital's checklist before going to the hospital. And even if you could, if you're in a part of the state where that's your only option, you may just be out of luck, notwithstanding this handy dandy checklist. Next slide. The second part of the Protecting Patient Care Act, which was passed in 2020, prevents individual practitioners, or prevents hospitals from preventing individual practitioners from providing information or counseling regarding a patient's health status. So it used to be the case that a hospital could prevent even individual practitioners who wanted to provide information to their patients or counsel their patients on abortion or contraception or end-of-life care. The hospital had the authority to do that. This statute prevents that. The one gaping hole that remains, though, is that neither of these statutes require hospitals to provide miscarriage management care, even where there is a serious risk to life or health. And this is a real issue in Washington. Women in Washington have been turned away from Catholic hospitals in emergency situations where they needed emergency miscarriage management treatment. And the hospital denied them care and required them to travel sometimes in excess of an hour to get to another facility. Next slide. Religious refusals by insurance carriers is also a major issue. There's a case before the Supreme Court right now that should be decided probably on the same day as the June medical decision that concerns the ACA contraceptive mandate. That's the part of the ACA that requires that employers and health insurance plans provide the full range of contraceptive options to employees. And the Obama administration, through rulemaking, had offered a workaround to religious employers and religious insurance carriers, or religious employers, that allowed the employer to opt out of providing coverage, but the insurance carrier would still provide the coverage so that the individual employee still received the coverage. The Trump administration, though, basically disregarded the Obama administration rules and issued a rule that would flatly exempt not just religious employers, but any company, not just religious entities, but any company with a religious or even a moral objection to the contraceptive mandate. So that issue is before the United States Supreme Court right now, and should be decided in the in the coming days. And that decision could again truly eviscerate the contraceptive mandate in the Affordable Care Act. In Washington, Washington law likewise allows religiously sponsored health insurance carriers to opt out of providing coverage. So this past legislative session, really the ACLU, Legal Voice, and a number of other organizations came together and advocated for the passage of House Bill 2554, which did pass, which imposes an assessment on insurance carriers that opt out of providing the legally required benefits. So at least there's no financial incentive for an insurance carrier to assert that it has a religious objection to providing abortion care or gender affirming care or any other type of care for that matter. Again, and at this point, there's a commitment by the state, a tacit commitment by the state to fill the gap and provide the coverage to fill any gap in coverage that is left by an insurance carrier opting out of providing coverage. But there's nothing in Washington law to ensure that that happens, and where the state is facing a tremendous budget shortfall, obviously there's a risk that won't happen. So that remains a gap. Next slide. Other battles in what I call the holy war on reproductive freedom. First, at the federal level, obviously we've already talked about efforts to expand religious exemptions in healthcare, but also there are efforts underway to expand religious exemptions in employment, education, public accommodations, and homeless shelters. There is also a movement to provide funding to crisis pregnancy centers that provide most of which provide no medical care at all. Some provide some medical care, but none of which provide the full range of, or really even any range of contraceptive options to their patients. And they certainly don't provide abortion or counsel for abortion. There's also the judicial establishment of a right to freedom of religion for corporations. And then at the Washington level, we talked about religious refusals. There are also, and we talked about Initiative 1698, which is the heartbeat bill that may appear on the ballot in November. But there are also two referenda 90 and 91, which are also being supported by both the Republican Party and some religious groups, which absolutely will appear on the ballot in November. And those are referenda to repeal the brand new statute that the legislature just passed in 2020 to require school districts to provide medically accurate, comprehensive sexual education or sexual health education in schools. There's also a challenge by the Cedar Park Assembly of God, a religious freedom challenge to the Reproductive Parity Act, which basically asserts that the Reproductive Parity Act requires that employers cover abortion to the same extent that they cover maternity care. The Cedar Park Assembly of God is challenging that statute as a violation of their religious freedom. And then finally, there is a huge rise in clinic protests by alt-right extremists with very clear ties to white supremacist groups. Next slide. Shown here is my client, the Planned Parenthood clinic in Spokane, and outside a group calling itself the Church at Planned Parenthood, which is like a who's who of alt-right groups in Washington, in Eastern Washington, that show up 700 people strong right outside the building on the other side of the wall from where patients are receiving care, to protest loudly with loudspeakers, block the driveway, and just basically create a massive circus outside of not just the Planned Parenthood clinic in Spokane, but they've expanded to Planned Parenthood clinics across the state of Washington and are now trying to expand across the country. Next slide. And if you needed any more evidence that there is a strong relationship between the anti-choice movement and systemic racism, and that connection is alive and well, this was an article that just came across my Facebook feed from the news yesterday. And the title of the article is "Black Lives Matter and Planned Parenthood in League with the Devil, so say sex ed opponents." Next slide. So if I were to leave you with anything, I think it's going to be a long road ahead. But I think 3 points I would want to make. And I think the first is that the reproductive rights movement really needs to stop ceding the moral high ground and conceding that this is a debate about religion. It's not. Again, the anti-choice movement is rooted deeply in gender oppression and systemic racism. We need to start calling that out. Litigation will be essential in the short term as a defense mechanism, but lawyers and litigation are not the answer to this. This is not about passing more laws to establish rights. This is a matter of what we really need is movement building, and movement building to get people, including our judges and legislators, to really see the connection between these various forms of oppression. Next slide. This is just a list of the work that Legal Voice has going on right now. I manage our reproductive rights, health, and work. These are just a few of the things that are on my plate. We deal with a much broader array of issues than this, but these are just some of the highlights. Next slide. And if you want more information, I would encourage you to go to our website. And the other organization that I would encourage you to really look at, though, is a reproductive justice organization called SURGE that is led by a really incredible leader, and they are doing the work of movement building. They're awesome. They need your support. They're new, and they're the only reproductive justice organization in Washington, or only organization organized specifically for that purpose. And then the last thing that I would encourage you to look at is the Safe, Healthy Youth Washington campaign. That's the campaign to combat referenda 90 and 91, which are attempting to repeal the sex ed law. And with that, thank you.
We have time for one really quick question. You had mentioned the impact on reproductive rights and access to it if SCOTUS affirms the Texas decision of 2 years ago. You touched on it just lightly, but can you just for a moment expand about how this is going to differ in states that are controlled by the religious right versus those states that have a more compassionate legislature?
Yeah, absolutely. I mean, either way, what this will do is allow states to pass abortion restrictions prior to fetal viability that the state purports to be grounded in women's health. And depending on how the court rules, really either way, it will be a lot easier to pass those types of restrictions, either because the standard for what the state has to show in order to justify a restriction as being based on women's health will be much lower, which means they don't really have to show much at all. Or, as I said, it will be harder to challenge those types of statutes. So it really opens the door for states to start imposing much more restrictive many more restrictions, and they've already been passing, states have passed like hundreds of restrictions, pre-viability restrictions since 2014, but it will open the door for them to provide more. And in many of these states, Louisiana now is down to 3 abortion clinics for the whole state. That's true in a lot of the South and Midwest, and this will just dramatically worsen that problem.
Thank you. Now, again, thank you so much and everything that Legal Voice does. We are honored to have you on here, and we have a few more questions that'll be happening afterwards during the panel.
No problem. Sorry for taking so much time.
No, it's a really good discussion to have. Everybody, we're going to take just a very short break because we're going to pop up a poll.